So to the extent I made you realize that, you're welcome. It's the order of the court that $20,000 will be paid to the plaintiff. Counsel for the plaintiff prepare that order so that I can then give that to the clerk and we can disperse it.
This case kicks off with a bold accusation from the defendant. "Thank you for evicting me and my family." But within seconds, the judge fires back. "You evicted yourself." And just like that, we're thrown into a legal tug-of-war over $20,000 sitting in escrow and a house that sparked thousands in payments, repairs, and heartbreak. On one side, the plaintiff claims rightful possession and wants that money released. On the other, a frustrated defendant citing unpaid security deposits, property taxes, and a contract that allegedly fell through. What's really going on here? Is this just a landlord cash grab, or did the defendant truly overstep the lease? And why does the judge seem so unmoved by the emotional pleas? Stay tuned, because this courtroom showdown goes from procedural to personal fast. The real twist? It's not about the money. It's about accountability. Let's dive in.
Anthony Momina here on behalf of plaintiff R&J Holding Group Holdings, LLC.
Azar Staffel on behalf of myself and my family.
Okay, where are we on this?
Your Honor, this is our motion to seek distribution of the funds held in the court's escrow account related to this case. Just to recap, two $5,000 payments total, which was the lease payment amount, incidentally, were placed into the account pursuant to the standard escrow order that was entered during the pendency of the case in chief. And then subsequent to the issuance of a judgment of possession, there was an appeal, and Your Honor entered another order, a bond on appeal,
Yes.
under which two additional $5,000 payments were made into the court's escrow account. I've confirmed with the clerk that $20,000 is currently being held. There was an appeal, obviously, hence the appeal bond.
Let's pause right here and break down what the plaintiff just explained. They're asking the judge to release $20,000 from the court's escrow account, but this isn't just loose change. These are structured lease payments deposited during the ongoing legal back and forth. Now here's the legal key. Two $5,000 payments were initially placed under a standard escrow order, and another two followed after an appeal bond was ordered when the tenant challenged the court's possession ruling. This isn't just rent, it's collateral for staying in the home during litigation. By confirming no pending appeals, the plaintiff is tightening the legal noose, saying, "The case is closed, the money's ours." Do you think escrow rules should always favor the property owner in cases like this? Or should tenants who've invested in upkeep have a say?
That appeal was dismissed by the Washtenaw County Circuit Court. There was a subsequent appeal to the Court of Appeals that was processed as an appeal of right when in fact it should have been otherwise, and that court dismissed the appeal. So there are no pending appeals on this matter, Your Honor. The matter is final and closed. And as an administrative action, I would ask that the court authorize the distribution of those monies to my client. Thank you.
Response.
Well, according to MCR 3.31, this was an injunctive bond that supposed to protect both of us because we counter-complained against.
Why was it an It wasn't an injunctive bond.
It should have been because we applied plaintiff and it wasn't granted. But this plaintiff case still is in pending status with federal court, and we paid $10,000 security deposit. We want them back.
Now here's where it gets heated. The defendant steps in, passionately arguing they're owed more than just a refund. She lists property taxes, homeowners insurance, and over $44,000 in maintenance expenses she claims to have paid during her time in the home. Let's be real, most tenants aren't paying property taxes unless there's a unique agreement in place, which she hints was tied to a failed sale. And here's the legal twist. Even if those payments happened, they're outside the scope of this particular court's jurisdiction. Did the defendant bite off more than she could legally chew? Or did the landlord let her believe ownership was coming? Drop your take in the comments, because this is where financial duty and legal boundaries collide.
And we also paid for over $44,000 of expenses that we paid the property taxes, we paid the homeowner's insurance, we update and upkeep, and they even charge us attorney fees, Your Honor. And I have the sheet to prove it, and therefore we are entitled to this $20,000.
Why don't we get clear, first of all, what the $20,000 is? The $20,000 was escrow pursuant to the basically summary proceedings action that had been filed.
The judge is now laying it all out, and if you're not familiar with summary proceedings or escrow bonds, here's your crash course. The $20,000 wasn't just dropped in randomly. The court ordered those payments while the tenant stayed in the home, and later, those same payments doubled as the appeal bond. So, while the defendant argues for reimbursement, the court is saying, you paid to stay, not to invest. It's a sharp distinction that shows how legally clean this case really is, despite the emotional mess. Think about it. If you're living in a home pending an appeal, should those payments ever come back to you? Or is that the price you pay to delay the inevitable?
That is not under Section 3 of the court rules. That is actually under Section 4 of the court rules regarding the issuance of an escrow order. I issued that order. You complied, as counsel has indicated, with 2 months of that. Albeit late, there were 2 payments put in. Judgment was rendered. You appealed that judgment. Also pursuant to the court rules, in, again, Chapter 4, you will see that the bond on appeal, I could have set it theoretically at whatever, or ordered whatever bond, but where there has been an escrow order, that escrow order then effectively becomes the bond on appeal. And that's what happened. And so then there were 2 additional payments prior to the dismissal of the appeal that then makes the $20,000. So that we're all, whether we're not on the same, we can all be on the same page or not. That's what happened, and that's why the $20,000 is there. I don't know what you're talking about in terms of objective relief. I don't know any of that. That has nothing to do with me in this court. The purpose of that, and the 5,000 was the amount of the lease, basically the lease price of the premises.
Exactly.
All right. You were in possession of the premises up until such time as the writ. I don't know if the writ has been executed or not.
And
But-
the return has been filed by the sheriff.
Got it. So you would have had to have paid that amount to be in possession of the premises up until whatever point in time and during appeal. So I'll let you make additional argument, but it seems to me that the $20,000 should be paid over to the plaintiff because of your occupancy of the premises.
Permission to speak, Your Honor?
Go ahead.
What about our
Here comes the pivot. The defendant brings up the security deposit, arguing it should factor into the $20,000 ruling. But legally, the judge is right. Security deposits follow a completely separate statute, the Security Deposit Act, which governs how and when landlords return that money. The twist? That issue was never formally raised in this case. And without that legal filing, the court can't and won't touch it. This is a perfect example of how missing a single step in legal procedure can cost you big. Have you ever felt like the court ignored a key part of your case? Or do you think rules like this are necessary to keep things from spiraling out of control?
security deposit, Your Honor? What about the payment of property taxes and homeowners insurance they forced us to pay in anticipation of the sale, which they breached the contract and they never did, Your Honor.
That would have to be taken up someplace else in terms of the property taxes and whatever. In regard to the security deposit, the security deposit is the disbursement of the security deposit is taken care of pursuant to an entirely different statute.
I beg your pardon?
There's the Security Deposit Act, which governs how that is how that gets returned and or not returned, what it can be applied to. That's not before this court.
Which court is this before you?
Pardon?
Which court should I go and ask for return of?
I can't give you legal advice. I'm just saying that issue, I'll put it this way, that issue is not before the court. That has not been raised as the return of the security deposit. Usually is something that takes place after the tenancy. Sometimes it's dealt with during the course of a summary proceedings case, certainly, but that has not been raised here. It is not before the
I'm
court.
raising that today, according to ex parte emergency motion and filed, Your Honor.
I don't know that it would be, I don't know that all of the compliance, Gustavo, the act is very specific about certain things that have to happen in order for an issue under the Security Deposit Act to be ripe to even be heard before the court. I'm not even sure all of that's happened. You can't just say, I need you to deal with this. That's not how it works.
Okay, I petition again, Your Honor.
Well, you can do what you want, Ms. Staffeld. I'm just telling you, I'm not dealing with the security deposit. I'm just not, it's not before me. The only issue before me is the $20,000 that is an escrow and its disbursement. Is there anything else you want to say?
Thank you for evicting me and my family out of our house, Your Honor. God bless you.
But this moment right here hits hard. The defendant, clearly emotional, says, "Thank you for evicting me and my family." But the judge doesn't flinch. You evicted yourself by not complying with the lease. This isn't just legal commentary, it's a reality check. A lesson in personal responsibility. The judge goes further, calling out the defendant's habit of blaming others, the landlord, the court, instead of owning her part in the lease violation. It's a brutally honest moment, and you can feel the shift. This isn't about money anymore. It's about learning from your own choices. Do you think the judge went too far here? Or was this exactly the tough love needed to cut through the courtroom emotion?
Well, I guess you're welcome. I didn't evict you. You evicted yourself by not complying with the lease. So don't try to put that on the court. Sometimes people, when they have problems in life, have to take the responsibility for their own actions and can't sit there and try to blame the plaintiff or blame the court or blame everybody else in the world. Those are the people that have real problems because they can't take it on themselves to do the right thing.
Let's not miss the quiet power move here. The judge ends it with full clarity. Prepare the order. The $20,000 goes to the plaintiff. But because the legal facts, not emotions, govern this decision. It's not about who cried louder or who paid more out of pocket. It's about who followed procedure, who complied with court rules, and who didn't. If you've ever wondered how much emotions matter in court, this is your answer. Not much, unless they're backed by proper filings, statutes, and proof. This was cold, clean, and legal, just how the system was designed. What would you have done differently if you were in her shoes?
So to the extent I made you realize that, you're welcome. It's the order of the court that $20,000 will be paid to the plaintiff. Counsel for the plaintiff prepare that order so that I can then give that to the clerk and we can disperse that.
Thank you so much, Your Honor. Appreciate your time.
We know this is gonna happen, so we are submitting this right now.
So, what's the final takeaway here? The judge ruled that the $20,000 in escrow belongs to the plaintiff because it was paid strictly to retain possession during the lawsuit and appeal process. The defendant's claims of extra payments and broken contracts? Irrelevant in this forum. And the emotional weight of being evicted? Legally dismissed based on non-compliance with the lease. This case reminds us, in court, procedure is power, and failing to raise the right issue at the right time, like the security deposit claim, can mean walking away with nothing. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more real cases, more legal drama, and more unexpected rulings coming your way. Don't miss it.